Ladies and gentlemen, welcome to our webinar on the subject of the recent developments in the English civil procedure in the light of the sanctions, namely anti-suit injunctions and anti-suit injunctions, the recent battles of jurisdictions in such cases, and some important surrounding points, such as access to justice. I am Ekaterina Shostrand, a dual qualified barrister. I have been practicing for 20 years in the field of international commercial litigation and arbitration. I'm based in London and I'm running my own boutique practice. I'm delighted to introduce my learned colleague, Mr. Alexander Nazarov, who is a Russian lawyer from Better Chance, a Moscow-based law firm.
Good afternoon, ladies and gentlemen. Good afternoon, Ekaterina, and thank you for the invitation to participate in this webinar. I'm indeed a Russian qualified lawyer and advocate. I'm associate with Better Chance, a leading Russian full-service law firm. I'm practicing domestic and international litigation and arbitration. And I'm delighted to participate in this webinar, and I hope to fruitful discussion.
Alexander, thank you very much. And I think from now we shall proceed with the presentation. The main focus of our talk today, though not the only one, is probably the hottest case in the area. It is the case of Unicredit Bank, a company incorporated in Germany, and Ruschem Alliance LLC, a Russian company. In the United Kingdom, in English courts, the case has gone through all the appeal stages, from the first instance to the Supreme Court of the United Kingdom. The Court of Appeal rendered its decision, handed it down in February 2024, and the appeal to the Supreme Court was heard in April, just over a month ago. The Supreme Court announced its judgment, so we know the result, we know the outcome, but the judgment has not been handed down formally yet, so we don't know the reasoning of the judges, but hopefully we will get the full judgment shortly. The facts of the case are as follows. Ruschem Alliance, in short RCA, entered into engineering, procurement and construction contracts for the construction of gas facilities in Russia. Performance by the contractor of those contracts was secured by on-demand bonds issued by Unicredit Bank. And those bonds were governed by English law in terms of dispute resolution. The bonds provided for ICC arbitration in Paris. Consequently, the contracts were terminated due to the contractor's non-performance of their obligations, citing the EU sanctions as its reasons for doing so. RCA issued a claim for payment against the bank before the Russian Commercial Court of St. Petersburg and the Leningrad region, known in Russia as the Arbitrage Court, in relation to the bonds. And that was on the basis of Articles 248.1 and 248.2 of the Russian Commercial Procedure Code. These are fairly new provisions, and in general, they confer exclusive jurisdiction on the Russian Commercial Court over disputes between Russian and foreign parties in certain circumstances. Here, I take a pause and pass the word on to Alexander, who will tell us a little bit more about these fairly new legislative provisions, what they entail, what is the scope of their application, and so on.
Thank you, Katerina. Indeed, these two articles, 248.1 and 248.2, are fairly new in the Russian legal system. They were first introduced in June 2020, which was long before the massive sanctions against Russia were adopted. But they started to have been applied by the Russian parties and Russian courts extensively since February 2022. So basically, Article 248.1 provides for exclusive jurisdiction of Russian courts over disputes involving sanctioned entities. Section 1 of the said articles, as you may see on the slide, states that unless otherwise provided by the agreements of the parties or international agreements of the Russian Federation, Russian courts would have exclusive jurisdictions over the matters first involving persons against which sanctions were applied, And second, where the dispute arose out of the sanctions. So it means that in such case, the parties may not be sanctioned, but when the basis of the dispute is the sanctions, Russian court would have exclusive jurisdiction. That said, Section 1 only refers to situations where otherwise not provided by arbitration agreement or forum selection clause. Apart from that, Section 4 of Article 248.1 provides that even if there is an arbitration agreement or a forum selection clause, which became unenforceable due to the restrictive measures applied against the party, in such case, such dispute can be referred to the jurisdiction of the Russian court. It also provides that such sanctions should limit the parties' access to justice. And this is actually essential. But as I will elaborate further, this criteria has been understood by the Russian courts as not critical, and they believe that the mere fact of sanctions themselves is sufficient to conclude that the parties' access to justice is limited. To briefly touch upon Article 248.2, this provides for the party's right to apply for an anti-suit injunction only in cases where the dispute concerns Article 248.1, which is the dispute involving sanction statuses or the dispute which arose out of sanctions. So in no other case, Article 248.2 can be applied. Basically, if there is such a dispute that falls within the provisions of this article, a party can apply to the Russian court for an anti-suit injunction. And in this case, the party should prove some basic facts that there is a dispute with the foreign party in the foreign court or in foreign arbitral institution, and that such dispute falls within the scope of Article 248.1. If the Russian court is satisfied that it would have exclusive jurisdiction under Article 248.1, it may grant an anti-suit injunction based under Article 248.2. It may also, as you may see at Section 10 on the slide, the Russian court may also, at the request of the applicants, award a sum of money, which would be a fine for the violation of the anti-suit injunction. So this is what can be briefly said about Articles 248.1 and 248.2 of the Russian Civil Procedure Code.
Alexander, thank you very much for this valuable insight. Could I just please clarify a couple of points? First of all, is the right to bring proceedings in Russia in such circumstances conferred only on the sanctioned parties or sanctioned party, or can a non-sanctioned party start proceedings in Russia in such situations? And second question, in such circumstances, as we have now discussed, does a sanctioned party actually have an option to start proceedings in Russia, or it must start proceedings in Russia according to Article 248.1?
Thank you for the question, Ekaterina. Speaking of the first one, so as elaborated, as explained in Section 2 of Article 248.1, it may be applied not only by the sanctioned entities or by the Russian entities, but also by the persons in case the dispute arose out of sanctions. That means that non-sanctioned entities may also apply to the Russian court based on Article 248.1. And as to your second question, actually, the provisions of the APC in this regard are optional. So the party may decide if, given the circumstances of the case, it wants to apply to the exclusive jurisdiction of the Russian court, or it may proceed with the foreign court, or arbitration institution as provided by an arbitration agreement. So this is not mandatory for the party, and it's up to the party to decide in circumstances of the case.
Thank you, Alexander. I think that is quite clear now.
Thank you, Katerina. And I would like to briefly elaborate on the criteria of access to justice, which I touched upon when discussing Article 248.1. So the Russian case law actually developed in this regard, and the leading case is the Supreme Court's judgment in Ural-Transmash versus PESA. So in this case, there was a contract for supply of cars, which provided for resolution of disputes by arbitration by Stockholm Chamber of Commerce arbitration, seated in Stockholm. SEC arbitration was commenced by PESA in accordance with the arbitration agreement, and Ural-Transmash applied to the Russian court for an anti-suit injunction, referring to the Articles 248.2 and 248.1. The Supreme Court decided that no anti-suit injunction should be granted in this case because the LCC award has already been rendered, and that simply meant that there is no proceedings to be restricted. But apart from that, obiter dicta, the Supreme Court said that the mere fact of imposition of sanctions against the Russian party participating in international arbitration in the foreign state is considered to be sufficient to conclude that access to justice of such Russian party is limited. So the idea of the Supreme Court was then reflected in a number of judgments of lower courts, and it can be said that in 90% of the cases currently considered by the Russian courts concerning Article 248.1 or 248.2, this decision of the Supreme Court is referenced. So this is how the case law as to Articles 248.1 and 248.2 developed in Russia.
Alexander, so if I understood correctly, there is a presumption as a matter of Russian law that where sanctions are imposed, the party or parties who to which sanctions started to apply basically would be prejudiced in its access to justice abroad.
Indeed, Ekaterina, this is the current approach of the Russian courts to the issue of limitation of access to justice. It can be actually proven by the other party that in a particular case, the access to justice was not limited because the other party could engage external counsel, for example, or pay arbitration fees. But in most cases, the courts would merely reference the Supreme Court's judgment in the Ural-Transmash case and say that it is sufficient to conclude that the access to justice is limited.
Thank you very much.
Thank you.
I think we can now turn again to the proceedings in the English courts in Unicredit Bank. And following the start of the proceedings in Russia, the Unicredit Bank applied to the English courts for an anti-suit injunction. The bank's position was quite simple, is that RCA is bound under the terms of the bond contracts to seek resolution of the disputes via ICC arbitration with the seat in Paris, and the law governing those arbitration agreements was English law. And it should also be noted that the bank did not start any proceedings, any arbitration proceedings. So the bank applied to the English courts for an interim injunction to start with to restrain the Russian proceedings, but in the first instance, it was unsuccessful. The trial judge held that the English court did not have jurisdiction because the arbitration agreement was governed by French law as the law of the seat, and secondly, because the English court was not the appropriate forum, as the bank could obtain substantial justice in the arbitration in Paris. The bank appealed that decision, And it should be noticed that while the Russian Commercial Court claimed its jurisdiction in the matter, and although it wasn't obliged to do so as a matter of Russian law, the arbitrage court did hold the progress of the case to allow for the issues before the English courts to be resolved first. So in the Court of Appeal, many different issues and points were raised and considered. And the first matter was establishing the criteria for determining whether the English courts could claim jurisdiction in this matter, and whether the English court could make a decision in relation to the anti-suit injunction. RCA is not domiciled in England and Wales and has no presence in this jurisdiction. So in that case, the bank had to satisfy 3 requirements to establish jurisdiction of English courts. Namely that, firstly, there is a serious issue to be tried on the merits. Secondly, there is a good arguable case that the claim falls within one of the jurisdictional gateways provided by the civil procedure rules. Well, basically, it's something linking the dispute to England and Wales. There are some factors that could link it to this country. And thirdly, that England and Wales is the proper place in which to bring these proceedings. As regards the first limb, serious issue to be tried on the merits, the Court of Appeal obviously had no difficulty in establishing that. So it's focused on the second and the third issues going forward. The gateway, the link to England and Wales, relied on by the bank was that the claim in respect of the contract is governed by English law, and that is because of the principle of the severability. Section 7 of the Arbitration Act 1996, for instance, provides for severability of the main agreement and the arbitration agreement. So the bank had to prove that the governing law of the arbitration agreements in the bonds was English law, i.e. the same as the substantive law of the bond agreements. The Court of Appeal examined the governing law of the arbitration agreements through the principles which were laid down in the famous case Enka and Chubb. In that case, which was a Supreme Court case, it was established that under English law, the law applicable to the jurisdiction agreement will be either the law chosen by the parties to govern it, or in the absence of such express choice, it will be the system of the law with which the arbitration agreement is most closely connected with. And the Supreme Court set out a number of principles which provide guidance on this point. So in relation to the Unicredit Bank application, the Court of Appeal applied the general rule that a choice of law for the main contract carries with it a choice of law for the arbitration agreement. And that the parties' choice of a particular seat of arbitration in order to find a neutral forum for their disputes is not enough on its own to displace this rule. So it's something like a strong presumption that can be rebutted by some factors. But in the present case, in the Unicredit case, the Court of Appeal decided that those factors were not present. And it concluded that the arbitration agreement in the bonds was governed by English law. Well, I would like to take a quick pause here and quickly talk about the Anka case, which, while it's still a very strong authority in the English law, it has been subject of a certain amount of skepticism in the legal community, skepticism expressed by the lawyers, subsequently by the Ministry of Justice, when it brought its draft arbitration bill, which is now going through the legislative process in the UK, and even by the lawmakers. And interestingly, the very first clause in the draft bill actually deals with the choice of law applicable to the arbitration agreement. And it is not the law governing the main substantive agreement, it's actually the law of the seat. So in the future, we'll see how the situation is going to be resolved. Obviously, we're going to see, I think, very, very different outcomes based on the new law when it comes into force, and provided that this provision is retained, namely that the law of the seat will be the law applicable to the arbitration agreement. But at the moment, ENCA, of course, is good and strong law, and it was rightfully applied by the Court of Appeal in the Unicredit Bank case. So after that, the third limb that the Court of Appeal had to determine was the English courts, whether the English courts were the proper place for Unicredit to bring its application. RCA argued that substantial justice could be obtained in the ICC arbitration in Paris, and Unicredit counter-claimed that RCA's position was sort of abusive in that respect, because it had already established or sought to establish exclusive jurisdiction of the Russian courts. So Unicredit also said that there was a real risk that substantial injustice could happen if, or rather say, substantial justice could not be obtained if the claims were to be heard in France, because French courts did not issue anti-suit injunctions. And if the bank were to be awarded damages instead, this would not be sufficient remedy. And anyway, any such award would not be enforceable in Russia. And the Court of Appeal noted that the High Court had previously considered evidence on all these points in the disputes between Deutsche Bank and RCA and Commerzbank and RCA, largely on the same facts, at least very, very similar case. For example, Deutsche Bank had also issued bonds to RCA in relation to the contracts that the RCA had entered into with the German contractors. The Court of Appeal said that the facts of the Deutsche Bank and RCA were practically identical to those of the Unicredit Bank and RCA. There were some small differences. For example, in the Deutsche Bank case, the application was for an interim, not final, anti-suit injunction, and the application had been determined on a without notice basis, meaning that RCA did not have the opportunity in that instance to make its representations to the court. So going back to the case we're concerned with, Unicredit case, the Court of Appeal decided that the English courts were the appropriate forum for hearing the applications, and ruled that by initiating the proceedings in Russia, RCA was in breach of its agreement to arbitrate under the bonds, and therefore it was necessary to grant an anti-suit injunction requiring that the RCA should terminate those proceedings. And accordingly, RCA was ordered to discontinue the proceedings in Russia. And as I've previously mentioned, the case was appealed. The Russkian Alliance brought its appeal against this decision. The appeal was heard by the Supreme Court, and we now know that the Supreme Court has dismissed the appeal, and the judgment of the Court of Appeal stands.
Thank you, Katerina. And I would like to briefly touch upon how might Russian courts react to English anti-suit injunction. And I think that the best way to explain this would be to provide examples of the cases that you actually referred to, which originated initially in Russia. The RCA cases against Unicredit Bank, the Deutsche Bank, and the Commerzbank. So all of these three cases were initiated by RCA in Russia despite the arbitration agreement. As you already explained, there wasn't ICC arbitration agreement in each of these cases. But the Russian court, despite the jurisdictional objections made by the banks, in all three cases decided that there is an exclusive jurisdiction of the Russian court based on Article 248.1 of the civil of the Commercial Procedure Code. The set of circumstances in each case is a little bit different, but the way the cases developed, and the outcome seems to be the same. So you may see that in each of the cases, there was an application for the stay of the proceedings, which happened in November 2023. And for the case against Unicredit Bank and the case against Deutsche Bank, RCA did not oppose to the stay of the proceedings. So the stay was granted, and it was specifically mentioned by the Russian court that the stay is granted until the decision of the English Court of Appeal is effective. The situation was a bit different for the case of RCA versus Commerzbank, because the motion for the stay was requested subsequently. And probably in February 2024, there was already an understanding that the Court of Appeal would not change its decision, and that there will be the anti-suit injunction granted by the English court will be upheld. So in this case, it was only requested by the Commerzbank, and it was not supported or simply not opposed to by RCA. And in this case, the motion for the stay was denied by the Russian court. It also makes sense to briefly refer to the developments after the decision of the English court. So the proceedings were renewed in all the cases, and you may see that it was the early May for the case of Unicredit Bank, and it was February 2024 for the case of Deutsche Bank. In each of the cases, the Russian court granted the freezing corridor, which happened quite recently, just a couple of weeks ago, and the assets of these banks in Russia were frozen, so that the Ruskim Alliance can enforce its claims against the assets of these banks in Russia. And it also worth mentioning that just recently, on 29th of May 2024, the case of Ruskim Alliance versus Deutsche Bank ended with the judgment of the Russian court. And the Russian court partially granted the claim of RCA and awarded the sum of money of more than 200 million US dollars. So we may see and conclude from these cases that in case the Russian party decides to comply with the English anti-suit injunction, in such case, Russian court would support, or would probably support the Russian court, the Russian party's position. But when the Russian party has no interest in compliance with anti-suit injunction, or for any other reasons, the court decides that it should not be considered. In such case, it will be disregarded. So this is how the situation is developing right now in Russia. We may see what may happen in the future.
Alexander, thank you so much for giving us a fuller picture and for this very helpful update on the development in the Russian courts in relation to these cases. I think we will talk about this situation, this, I would say, quite unusual and difficult situation that the parties find themselves in following conflicting decisions of the courts in the two jurisdictions. We'll talk about potential consequences a little bit later. But for now, if I may, I would just like briefly to mention and discuss a couple of other cases which were heard by the English court following the Unicredit and RCA. And the second case of Mr. Magomedov and other claimants and Transneft and other defendants. So turning to the Barclays case to start with. That was a dispute in connection with the derivatives agreement, which provided for English law as the governing law, and the LCIA with seat in London as a dispute resolution forum. So in this particular case, there was no question mark or conflict between the governing law of the main agreement and the law of the arbitration agreement as such. Well, clearly it's English law. The complication was that web was added to the sanctions list in the UK, the EU, and in the US. So web started court proceedings in Russia to recover the money in connection with the master agreement. Following that, Barclay made an application to the High Court in England for an interim anti-suit injunction and anti-enforcement injunction. And these injunctions were granted initially in February 2024. And the hearing we're concerned with that I'm going to talk about, that particular trial took place on the return date, which was the 15th of April 2024. So this is a very, very recent case. And it was decided already following the decision of the Court of Appeal in the Unicredit and RCA case. So in the Barclay Bank case, there were two main issues before the court. First of all, whether the arbitration agreement was frustrated, and secondly, whether a delay by Barclays in making its application to the English court for an injunction should preclude the court from granting this application, whether that was sufficient basis for the refusal of an injunction. In relation to the first point, frustration, the arguments advanced by the web were the difficulties with securing legal presentation, particularly for a sanctioned party, and problems with paying legal and LCA fees, inability of witnesses and representatives to attend hearings in person if the case were to progress into the jurisdiction of the LCA with the seats in London. So these are roughly the arguments, or broadly speaking, the arguments presented by web. Well, in relation to frustration, the court has decided that yes, it is clear that there is a reduced pool of lawyers for web to choose from, and potential delays and hurdles, extra hurdles in relation to paying its lawyers and paying arbitral fees. And there is also clearly a need to conduct the arbitration remotely. But in the court's view, all of that fell into the category of a more onerous performance. The performance wasn't impossible. And web wasn't precluded from accessing justice in that sense. There was no frustration. Also, the court paid attention to the fact that web was legally represented at the hearing. So there were lawyers, law firms that were and are still prepared to assist such parties in this situation. And web did somehow manage to pay the legal fees and various other fees. Also, Barclay indicated that it would agree to the LCA hearings being conducted remotely, virtually, and the judge made a comment that the issues between the parties in this particular case were of a purely legal nature, so remote attendance by the parties would not lead to injustice. Well, one might think that in a different case, the court might have come to a different view on this point, for example, where there is substantive evidence of fact, quite a number of witnesses to give that evidence, and they would have to participate in the court hearing. A remote hearing would not be really an ideal scenario, an ideal setup. Far from that. This kind of case would need an in-person hearing. So in that kind of situation, the English court might have come to a different view and said that, well, no, actually remote hearing is not going to work in this situation. But going back to the facts, before the court in the Barclays Bank and Web case, the court thought that the purely legal nature of the issues between the parties meant that a remote hearing would not hinder access to justice, would not hinder the quality of justice, and it would work very well. Also, there was another quite separate reason why the arbitration agreement, in the opinion of the court, was not frustrated in that case. The court had noted that the parties did foresee back in 2019 the risk that sanctions might be imposed on Web in the future, because several amendments had been made to the master agreement in the course of the previous years. And the last amendment, if I'm not mistaken, was exactly in 2019. It dealt with technicality in relation to a termination event. And the court said, well, if the parties did foresee that Web could be added to the sanctions list in the future, they might have well reviewed their position in relation to the dispute resolution clause and have chosen some different forum, have come up with something else, but they didn't. So since the event was foreseeable, and that was quite clear on the facts of this case, so there can't possibly be a frustration. So on the objective construction of the master agreement, both parties must have agreed that the dispute resolution clause, the LCIA arbitration, was to continue to operate in any circumstances. So that's the frustration point. And very briefly, as regards the second point, the delay by Barclays in bringing its challenge in the English court. The English court found, among other things, that that delay had not resulted in a waste of the Russian court's time or resources, and the interim order granted to Barclays was made permanent. The case of Magomedov and Transneft turned on different facts. It was a High Court case, litigation, not arbitration. It was a claim brought by Mr. Magomedov and a number of other claimants based on effectively economic torts, alleging various conspiracies. Transneft was added to the EU sanctions list, but as regards the UK sanctions, there were no asset freezes in place. That's my understanding. Transneft was under some kind of limited UK sanctions, but not asset freezes. Nonetheless, it experienced considerable problems in paying its lawyers, and the judge paid very close attention to this, considered this fact very, very carefully, and basically decided that on the evidence before him in relation to the very real difficulties that Transneft experienced in litigating in England and Wales, difficulties that may very well be overcome in the future, but they had not been overcome on the day when the application was heard. So the invocation and the application of Article 248 of the Russian Commercial Procedure Code was consistent with the justification that this legislative provision was given in the explanatory note. So basically, the application of Article 248 might in some circumstances be justified. So this is one case, it's first instance, but nonetheless, it's a case where an English judge did think that there might be circumstances where the application of the provisions in the Russian Commercial Procedure Code conferring exclusive jurisdiction on Russian courts it might be justified. Well, in that particular case, Magomedov and Transneft, the judge still ruled in favor of the claimants and granted an anti-suit injunction. But nonetheless, it's interesting that the English court in principle considers a possibility, it may well be possible in some situations, for the affected Russian parties to claim the exclusive jurisdiction of the Russian courts, and that's in the eyes of the English courts.
Thank you, Katerina, for this overview. I guess the latest case that you mentioned gives us some hope, at least, that the battle of jurisdictions would be, if not ended, but a bit eased between the Russian courts and the English courts. So if the courts show each other some kind of comity and recognize each other's rules in respect of the exclusive jurisdiction, that would probably resolve the issue at some point in future.
One might hope so, Alexander. Yes, obviously there are still various controversies and difficulties there, but yes, there is a chance that in the future, with some kind of facts will come to light that will make it possible to reconcile the positions of the two jurisdictions. And however, at the moment, I think what the parties are faced with in such situations where there is a Russian court case based on the exclusive jurisdiction according to the Russian Commercial Procedure Code, and then an anti-suit injunction, and then anti-suit injunction in the English courts. It's again, that's my personal interpretation, but it's something like a deadlock, really, where if you do this, you're faced, or don't do this, we don't comply with this court order, you're faced with consequences. If you don't comply with the other court's order, you are faced with the consequences. For example, in terms of the non-compliance with the injunctions issued by English courts, it's an established position that a guilty party may be found in contempt of court, and the consequences can be quite severe, up to, for natural persons, up to 2 years imprisonment. So clearly that's a factor, very serious factor to consider.
And actually in Russia, as I briefly touched upon when discussing Article 248.1, there's also a mechanism for paying a compensation to the party, to the injured party, if the court decides that such compensation should be paid for violation of an anti-suit injunction. And the amount of such compensation can be up to the claims made before arbitral or court proceedings. So it might be also an incentive for the opposing party to refrain from violating the Russian anti-suit injunction.
Yes, one can see that the potential financial consequences can be quite severe, well, very severe. And again, presently, the way I see it, it's a bit of a deadlock. However, going forward, I would say, and that's not just in relation to the Russian parties, but generally where there is, say, an international M&A or some other contract, any kind of contract that is governed by English law. I think if the parties wish to choose an arbitral institution and have an arbitration clause in their agreement, they should carefully think for now, at least until the amendments to the Arbitration Act, by way of, well, the arbitration bill that I just mentioned, until that bill becomes the law. It's very prudent to consider what sort of law should govern their arbitration agreement, given the ability and the willingness of the English courts to, say, issue anti-suit injunctions and adopt various other measures. to protect the parties' position. So I think the parties need to carefully consider the risks at the very initial stage of entering into their agreements, and think whether they would like to, and I would say that would be actually highly recommended, to choose and stipulate specifically in their agreement what would be the law applicable to the arbitration agreement.
I would agree with you, Katerina. This is actually the advice we usually give to the client. So given that until quite recently, a lot of commercial contracts, even between Russian parties and some Russian-related parties, were governed by English law. So now these parties are thinking how to potentially exclude the jurisdiction of English courts with respect to this contract. And this is also the advice that we give to such parties. But in Russia, by the way, the approach to the law governing the arbitration agreement is the one that is proposed to the draft bill, which is the law of the seat of the arbitration. That should be the law governing the arbitration agreement.
Yes, as I mentioned before, it's the same with the amendment to the English Arbitration Act, the new arbitration bill, which envisages in its current draft, and it looks like it's going to be that way, that the law applicable to the arbitration agreement of the parties in the absence of express choice of that law will be the law of the seat. Alexander, I think that concludes our webinar. Thank you very much for participating and holding this webinar together with me. And I would like to thank our audiences. Thank you for watching and listening to us.
Thank you, Katerina, and thank you everyone for joining this webinar. I hope it was helpful.